Welcome to Fox Williams' Forward Thinking podcast for World IP Day on the 26th of April 2026. This one is on top tips on IP. My name is Scott Steinberg and I'm joined by
Lucy Marlowe.
Lucy, do you want to kick off with the best tips for everyone?
Sure. So a starting point with IP is that obviously it's quite a complex, messy array of rights that often exist in a business. So a really key starting point is to just audit the business. So have a look at what IP you have. Some can be registered, some might be unregistered, and then see where there are gaps, or see where that you might have existing rights, but actually the business has evolved. So let's say you have a trademark for your core brand. Actually, you might have decided to launch more services or more products, and that was filed years ago, so you need to update it. So that's part of what an IP audit is about. Identify where there are gaps, fix them, and basically put your business in a much stronger position.
I agree, and that leads on nicely to number 2, which is protect early. Please protect early, because we often see IP sort of forgotten about until afterwards. And then clients will come to us and say, what do they do because someone else is using the trademark in a key territory? And then we have to start discussing rebranding, which is not ideal.
And also you've got like the prior rights there, which is that it's a first to file system.
Mm-hmm.
So it's really important that once you've decided that this is the brand that we want to launch, that you then come to lawyers such as ourselves and get a clearance search, so you know that your application is more likely to succeed and it won't be opposed. You're not going to infringe third-party rights, so you'll be in that position you just mentioned, Scott, of facing an infringement, and we get it on the register as soon as possible.
Yeah, which again is about, you have to think internationally, not necessarily cover every single territory that you ever might be in, but because there are sort of strategies to manage that. But again, as we just said, I guess it is similar, if someone's got your brand, or if someone's offering a similar product in another territory, what are you going to do about that? We need to come up with something early.
And you don't want to have launched your brand, let's say in the UK, and then find out that similar brands exist in the territories that are core to your business as well, and then be blocked from entering those markets and then face this patchwork of rights scenario, which isn't desirable for anyone. And think about like long term, like what are your distribution and your key market plans, and make sure that you have the scope to expand into those markets.
You should also make sure that the domains that you want to use are available, as well as social media accounts, because again, it can be more difficult if someone else is using that, and especially if you become well known, or you generate sort of goodwill in that brand. They might want more money to give you that domain or those social media accounts. So that's also something to watch out for from the start and put into your brand planning.
And on the theme of brand planning, once you have those trademarks, it's also really important that as a business you provide guidance to your organisation on consistent brand use, because we often see it when you have a particular logo, let's say protected, or a trademark, but then multiple variations are used throughout the business, some of which you might not have protection for, and then that becomes an issue when it comes to enforcing those rights. So you might have, for example, diluted your goodwill. So consistent brand use aligned with your trademark strategy is really important.
Yes, I agree, and also you can take advice on those brand guidelines as well, because it might be that there's something there that hasn't been protected that should be, to stop a third party from copying you later. We see a lot that sometimes, or we often see that these brand guidelines are released without sort of consultation.
What about, Scott, have you seen what happens when a business stops using a mark? Like maybe they just forget, like why is that a problem?
Well, trademarks are essentially use it or lose it. So in the UK and the EU, you have 5 years after registration, a 5-year period to use your trademark. If you don't, then a third party can come along and try and challenge those goods and services that aren't being used. So that is a risk.
Another area that I see, Scott, is about avoid premature disclosure of your designs or your potentially patentable inventions, because the issue with that is you could preclude yourself from actually being able to gain those registrations, because at the time of filing applications for designs and patents, it needs to basically be new and not commonplace. It is important that as soon as you have that idea for a design or a patent, that you take legal advice as early as possible.
But thankfully there's a sort of saving provision for designs. There is a 12-month grace period. We're not saying please you don't have to rely on it, but yeah, it's something to bear in mind that can be useful.
And sometimes businesses don't know when there's been an inadvertent disclosure, like Rhiannon and Puma, when Rhiannon posted an image of the trainers that Puma are about to apply for a registered design right-in, and then they weren't actually able to get the design because at the time of filing it wasn't new. So and it's on theme. This is a sports example, given that it's World Sports IP Day.
And another important point is clarifying ownership of IP, especially unregistered rights, because it's easier with registered trademarks, registered designs. You have a certificate that says who owns it, but it gets a bit messier when you have to rely on sort of proving your ownership or what the law says. So if you're an employee, then your employer will probably, not always, own the intellectual property rights. But if you're a third-party consultant, then the position in law is that generally you as the consultant own that IP.
And what about in terms of an issue that I often find is that businesses, when they use third-party content, that they do need to be careful with that. Just because something, for example, appears to be freely available on the internet to use, you still need to dig a bit deeper and check the license terms, the territory, the scope. Can you be used for commercial purposes? And if it looks like you are able to get a license, you still then need to keep a record of that and make sure that the business is compliant. And if you're not sure, then again, you can reach out to IP lawyers like us and we can advise on the terms of that licensing.
Well, keeping records is the next top tip, number 10. Because how do you prove your ownership of unregistered rights? You have to keep records to show your sort of development process, to show the creation process, why the things you did made it original. So yeah, that's definitely something to bear in mind, especially if you're relying on copyright.
And then the next top tip is once you've got your rights in place, that's not enough. You also need to monitor and enforce. So on the monitoring side, using the example of trademarks, we offer a watching service, and that's a very proactive, sensible step for businesses to take, as what we do is we scour the registries for similar or identical marks being filed, and if we consider that to be a risk to your business, we'll then alert you and you can try and stop that mark from making its way onto the register. It's also a really sound commercial step to take, because often a business might just dabble with filing a trademark application to see if they can get away with it before they launch, knowing that it might be similar. And if you're able to jump on that at an early point, you're more likely to achieve a swift resolution and stop that mark, one, securing registration, and two, being used. Whereas if that brand launches and it's been going for years and you ask them to rebrand, they're more likely to throw up some arguments and try and defend it, which is more costly. So the monitoring point is really important. And then on the enforcement side, it's very good having a trademark, but that gives you the right to stop third parties. So in order to protect the monopoly that the trademark grants you, you actually need to take active steps like what we just mentioned, so that your brand is the only brand, let's say, that for the goods and services that are covered by that particular registration on the market.
Yeah, exactly. You need to send a message as well to the market.
Yeah.
If you don't enforce your rights, then everything we've discussed doesn't really make sense. The next one, what about, you need a strategy, don't you, for infringement? So if someone copies you or is using your idea, obviously I mean the idea in terms that's been actually put in action, but then what do you do? I mean, do you write a letter to them? Do you issue a takedown notice? There's a lot to consider.
Yeah, and equally, like the tone that you did on the strategy that you decide to go down, because there's often reputational risks to consider as well. And not to create this David and Goliath dynamic. There are lots of options, and a key point just to flag here on the enforcement point, Scott, is the groundless threats. As a layperson writing to a third party claiming the infringement of certain intellectual property rights, like trademarks, for example, you could find that you're on the back of a groundless threats claim from the other side. So rather than you being the claimant claiming that the other side are infringing, they can say that the way in which you articulated your claims amounts to a groundless threat, and then you're facing that claim and the damages that they can pursue you for. So it's really important to get that initial advice at the outset as a claimant or a defendant as well.
Well, that's the next one, because number 13, cease and desist letters. You know, you might actually become a defendant just from launching your product or your brand or anything like that. You might receive a letter, a trademark application might be opposed. So again, you do need to consider your strategy for responding to that. How do we, I say we as if we're already acting for you, but how do we overcome that? How can you, sort of hopefully make the issue go away?
Yeah, and also just think about like what remedies you're entitled to as well, because a classic remedy in IP cases is injunctive relief, stopping the activity, but also consider a settlement sum to compensate you for the infringing act. So, and there's various ways in which that can be calculated, counter profits or damages, but that's probably too much for this quick run through of questions. What about making money from your IP, whether that's used or unused? What do you see there, Scott?
Well, that's definitely one of our top tips, that you should be making money from your IP. Yeah. When it comes to valuing a business, they will take into account IP in general. But you can also license your IP. We also see this in another form through franchises. There's many sort of well-known examples that you see all over the place where you can license your IP rights and someone else will sort of use it in a way that's hopefully and should be defined by a contract. Similarly, you can assign IP rights that you own, which means essentially just transfer. IP is a saleable asset, but it's also an asset that adds value to your business, as we said at the start.
Yeah, and then just the final wrap-up point is about the ongoing review. So, it's important that, going back to the initial point about audits, that you should look at the outset as to which rights you can protect through registrations and your own registered rights, and ensuring your IP house is in order. But naturally, businesses evolve, and you may have new products, new services, and it's important to make sure that your IP strategy is aligned with that, so that you're maximising the value of your IP.
Well, those were 15 of our top tips. We've got many more. Stay in touch.